All right, we got next up Paul Taylor. A lot of you know Paul.
Just a little bit of background on me. I grew up in the trucking business. My family has been in the trucking industry since 1935 or 1936 when Grandpa was the terminal manager for a trucking company in Fargo, North Dakota. And they continue to be involved, although less in trucking now, more in brokerage. So I have been representing truck drivers for 34 years, my entire career as an attorney. The first 10 years, though, I also represented trucking companies. So here's really what I do. I represent drivers nationally in 3 areas. First is wrongful termination. Those are cases under a law called the Surface Transportation Assistance Act. 2, I represent owner-operators on cases involving lease disputes. Say, for example, you're paid on a percentage and you think you might be getting skimmed from, and you probably are. And third is I represent drivers on DAC report issues. And then there's a smattering of things I do with respect to drug and alcohol testing. The people who profess they've never used marijuana and tested positive and can't possibly understand how that happened. I'm just going to give you a quick whirlwind tour of the Surface Transportation Assistance Act. Passed in 1982, signed into law by Ronald Reagan. It's a law that gave us 48-foot trailers and 80,000-pound roads on the national network, but it had a little provision in it called the Employee Protection Provision. And for purposes of the statute, an employee includes an owner-operator. And that law says no person may retaliate against a driver because that driver either A, makes complaints to the employer or the government about violations of commercial vehicle safety regulations, or 2, refuses to drive because driving would result in an actual violation of a commercial vehicle safety regulation, 3, refuses to drive based on a reasonable safety concern, and 4, gets retaliation is prohibited against a driver because the driver accurately records on-duty hours. Now, that's not the exact way I would have liked the statute to be written when President Bush added extra protections in 07 to include the logbook falsification protection against retaliation for false logbooks. So that's my bread and butter. And those cases go through the Department of Labor. The Department of Labor is much more friendly. Their judges are much more friendly to whistleblowers than are the federal courts in normal employment suits like sexual harassment, sexual discrimination, Title VII, age, things like that. We have a very easy standard to meet in those cases, which I'll get into briefly or shortly. So just to give you some examples of protected activities. Writing up a vehicle inspection, writing something up day after day because it's not getting fixed. If it's something that relates to a violation or potential violation of a commercial vehicle safety regulation, you're protected. Telling the boss, your equipment is junk, I got an audible air leak, a leaking hub seal, 4 bald tires, and I'm sick of running your crap. That's a protected safety complaint as long as it's made to a supervisor, any supervisor. Threatening to call the DOT on your employer because they got junk equipment, whatever it is. The case called Theron Carter versus Martin Transport. I know they're out there somewhere. I saw their booth. Maybe they're in here. That's a case that stands for the proposition threatening to call DOT is a protected safety complaint. So those are just examples. In other words, to have protection for making protected safety complaints, you have to have a reasonable belief, an objectively reasonable belief, that there is an actual or potential violation. You don't have to prove one actually exists. Another example of protected activity I told you about, refusing to drive because driving would violate a commercial vehicle safety regulation. Now, that statute doesn't say it has to be an out-of-service violation. It says any violation. So if you're 100 pounds over the legal limit and you can't slide your axles enough to bring it into compliance, you're protected against retaliation for refusing to drive, because I don't care if you're 10 pounds, 5 pounds, 100 pounds. We won a case, came down about 4 months ago, called Palter versus Central Cal Transportation. She was 650 pounds over on her axles. She was set all the way back in California, couldn't slide them enough to get it legal, and the dispatcher said, you can legal 35.5, which is a lie, and he said, slam the trailer. In other words, get it cranked up and slam on the brakes and try to shift a load of tires off the trailer tandems. We won that case. The judge said, well, he was attempting to coerce her to drive actually over. You're not going to move, and he believed that she couldn't move 600 pounds to get the load legal. So that's an example. There's other examples of protected activity. Refusing to drive because the weather is so hazardous that driving's unsafe or so likely to become unsafe. You all know the rule, no driver shall drive, when conditions are sufficiently dangerous, operations shall be terminated. 392.14, I believe, is the regulation. We had a driver, Cynthia Ferguson. I'll name some more names. Ferguson versus Prime. Well, their legal name is New Prime. She was told you could have been halfway around the country by now, chain up and go. She was at Sparks at the bottom of Donner and refused to go through during a bad snowstorm. So these are the types of protections you can get. We have habitual violators who we've sued multiple times. Had a case, Brian Ford versus Prime. He was on medication, narcotic medication, and they blacklisted him on DAC because he would not return the truck he had under lease, and they put an abandonment on DAC when he refused to return the truck because he was on narcotic pain medication. So those are some more of the minor things. But if you had or major things, if you had a tail light out or one of the 3 clustered marker lights out and you refuse to drive, you're protected. Now, not a lot of trucking companies want you driving there if you're not going to drive without, with one marker light out. But that is the law in those cases. So a little bit about what you can get as a remedy. So if you go through the process, if you win, and this is always if you win, you can get reinstated. That's the nice thing about most employment laws is if you're illegally fired, you're entitled to reinstatement. 2, you can get your DAC report cleaned up. Whatever retaliatory information is on there, and abandonments we all know are killers. You might as well have a positive drug test on your DAC report as have an abandonment, because you're not going to get hired. So you can get your DAC report cleaned up. 3, you can get your back pay, provided you've made sufficient efforts to look for work. That's called mitigation of damages. Next, you can get compensatory damages for mental pain and emotional distress. Getting fired is traumatic. Getting fired for doing the right thing and wanting to be a safe driver is humiliating. So, these are things. We had a case against R&L Transfer where a guy lost his home. He refused to go out in bad weather. Really bad weather. And I know there's some people say be a super trucker and man up and go ahead and go. I don't subscribe to that theory. If you're going to refuse to drive due to bad weather, you should be legally protected. So you can get back pay, compensatory damages for mental pain. The statute allows punitive damages up to $250,000. And the best thing is that if you win, you can recover attorney's fees. So that allows us to take those smaller cases. I will tell you what, one of my very early cases under this statute was a case where it was called Esch versus Roadway Express. He wouldn't go out in bad weather. He was suspended for a week. He was out $900, and darn, the company wasn't going to give him his $900. We tried it twice because it had a remand. We went to the U.S. Circuit Court of Appeals after an internal appeal, the Department of Labor, went to the U.S. Circuit Court of Appeals, and Mr. Esch got his $900, and the company wrote us a check for $70,000. And that's back when my rate was a lot cheaper. But I mean, that allows us. A lot of people get upset about attorney's fees sometimes. Oh, who should get attorney's fees? He should be working for 1/3. Well, nobody's going to work for $900 of 1/3 of $900. But the fact is that these lawyers here and the statutes we go under, we're allowed to take those really risky cases because of statute, because there's things that are in the public interest. Just a couple quick things. To protect yourself under this whistleblower statute, how am I doing for time, guys? Am I okay? Yeah, okay. You're all good with me talking. Oh, okay, to protect yourself under these cases, the best cases I get, and one of these guys said it earlier, is when we're contacted before somebody's really fired you, okay? I get drivers, they'll call me at 11 o'clock at night. My website lists my cell phone, and people can offer me to reach me at night. You know, hey, Mr. Taylor, I've got this truck. It's got an audible air leak, a leaking hub seal, 4 bald tires, and I'm afraid I'm going to get killed. What do I do? And we can tell them, this is what you should send on the Qualcomm or PeopleNet message. Please send tow. This truck is unsafe. Here's what's wrong. And you take pictures. This day and age, with the technology that you all get, there's no reason you can't protect yourself against claims of retaliation. You know, put good, clear stuff on the Qualcomm messages. Take pictures. You can. There's a tapeacall.com, and in all but about 12 states are single-party states where you can record and build that case and have that evidence. So, you know, just in case you need it, because one person's word against another is sometimes really difficult, and preserve those records, bills of lading, logs, toll tickets, things like that that can establish where you are at certain times. You know, that evidence is important. And one more bit of advice before I move on very briefly to skimming: stay off of Facebook. You know, I will tell you, start yakking about your case on Facebook is not good. I had a driver who said he was emotionally traumatized and financially destitute because of an illegal firing, and the other lawyer at deposition whipped out a Facebook page for my client saying he had just bought a race car. So this financially destitute driver just bought a race car, and I said, don't you think it would have been important to tell me about that race car you bought? So, you know, maintain good relations with your attorney. Quickly about skimming, if you're paid on a percentage, you are not entitled to receive a copy of the load confirmation sheet. You are entitled to see, upon reasonable notice, a copy of the load confirmation sheets used to calculate your rates. But you're not entitled to get copies, okay? A couple other areas where skimming occurs are markups on insurance. If you're buying your bobtail or physical damage through the company, you know, they'll mark it up. They're not entitled to unless it says so in the lease. Basics of the leasing regulations, which we sue out those cases in federal court. There's a right of action to sue them. Carrier cannot charge you back unless it's in the lease, and they have to charge you at cost unless the lease sets a specific amount. And third, anything that you're getting charged back, whether it's damage claim or even a $1.25 com data check charge, it has to be allowed for by the lease, and you're entitled to receive written proof of those charges. So that's it in a nutshell. I bet I went over my time.